When a company or an individual invents something new, like a vaccine, you're allowed to apply for something called a patent. And a patent gives you the right to be the only manufacturer of that product, to be the only entity that decides how that invention should be made, sold, distributed, and so on. Under international law, there's a framework called the TRIPS framework, which stands for the trade-related aspects of intellectual property rights. And TRIPS says that companies can patent new inventions, and the patent protects them as the sole entity that decides most things about that product for a period of 20 years. One of the problems during the pandemic has been, and it continues to be, the fact that Pfizer initially couldn't produce enough of the vaccine to supply the whole global market in a very short time frame. It meant that people couldn't get access to the vaccine, and many people died and were hospitalized. Well, if Pfizer didn't have the patent on the vaccine, it would have allowed other companies to copy the vaccine, to produce more of it, and more people could have had access in a shorter period of time.
We as Fix the Patent Laws have been calling for the reform of South Africa's patent law, mainly because it blocks access to life-saving medicine for ordinary South Africans. So governments are allowed to limit the intellectual property rights given to companies. They can do this by creating laws and policies that give companies, other than the IP holder, the right to make new medicine or use new production processes. This is called a compulsory license. Governments are allowed to import medicine that is manufactured in other countries but patented in South Africa, and that is called parallel importation. Governments can refuse to give companies intellectual property rights. For example, if a company says it's made a new invention by changing a medicine from a tablet into a syrup form, a pharmaceutical company might try to get another 20 years of exclusive IPRs on a medicine. But governments have the right to say this does not really count as a new invention. This is called a substantive evaluation of a patent. Right now, the South African government does not have these powers, but it can get them only if it changes its intellectual property law. This will translate into cheaper prices for the essential medicines we need to ensure a functional health system.
We have been advocating for domestic law reform on intellectual property for the past 10 years. And in that 10 years, we've managed to secure the intellectual property policy in 2018. As part of that policy, government undertook to enact certain laws, such as the Patents Amendment Bill, in order to make that policy effective. However, little progress has been made towards enacting these laws since 2018. Before the bill comes out, continue to monitor and report stockouts of essential medicines like ARVs, cancer, asthma, and TB medicines. This makes it clear how important it is to fix our broken IP system. Fixing the system will help us to ensure that there are fewer stockouts in future. So when the bill comes out, participate in a meeting to learn more about it and give feedback on what you think should be changed to make it more effective. Convince your friends, comrades, and neighbors to do the same. Join an organization like a clinic committee or a health organization that is trying to improve access to medicines.
Bendamustine is used for the treatment of non-Hodgkin's lymphoma. This is a specific medicine for people living with HIV that is diagnosed with non-Hodgkin's lymphoma. This medicine is available in South Africa, the originator product, at 4,500 Rand approximately. However, the generic product is not available due to the patent law in South Africa. If the patent law is changed, it will also then mean that the generic product, which would be far more affordable for the Department of National Health to put on the essential medicines list, will become available for the majority of patients that have to access the public sector.
What do we want to see included in the new IP bill?
more transparency in adjudicating patent applications.
Strict patentability criteria.
We want substantive examination of patent applications.
Implement pre- and post-patent opposition procedures.
Include workable procedures for issuing a compulsory license.
Adopt a more workable process for parallel importation.